court then declared that a trial within a trial should be held in order to adjudicate the contention by the state which alleges that such statements pointing out and/or warning statements were made freely and voluntarily, whilst the defense adhered to the fact that that was not the case. The state then called Magistrate Cronje as its witness in the trial within a trial, because she apparently is the person who presided over the alleged statement or confession which was allegedly made by accused number 2. Prior to that, obviously, the state also had called Colonel Mboto, who was also alleged to be the scribe who presided over the alleged confession allegedly made by accused number 1. Now, Mr. Mnisi addressed this court and stated that, in his view, there should also be a trial within a trial in relation to the admissibility of the audio recording which was made by Magistrate Cronje when she was presiding over the Section 217 interview in respect of accused number 2. My view is that maybe I should commence by saying the defense was given an opportunity by Mr. Baloyi, the prosecutor, to listen to the alleged audio recording which was made by Magistrate Cronje. This emanates from the fact that after Magistrate Cronje had given evidence and before she was cross-examined, the state, through the aegis of Mr. Baloyi, had indicated that it was in possession of an audio recorded tape, but had stated in court that the state was not going to utilize same and try and admit it to the evidence in the trial within the trial. Subsequent to the state changing its mind, and that occurred after the defense had had the opportunity of listening to the tape, the state then said it would appear that in order to bolster its case, it intends utilizing that audio tape and introducing it to evidence because Mr. Baloyi stated that it appeared that the allegations regarding the questions and answers which were elicited and presided over by Magistrate Cronje in what is termed the pro forma format, which is structured on 9 pages and 13 paragraphs, where the information which predicates and precedes the admissibility of a confession or statement has to be argued before this court after the elicitation of evidence and counter-rebuttal evidence by the accused. Consequently, to accommodate the concern of Advocate Mnisi, I there and then said, because the precursor, as he terms it, is not apparent to him, to this court, it was apparent in that that precursor is predicated on the fact that the defense is alleging that the rights of accused number 2 were violated, the constitutional rights of accused number 2 were violated, in that when this tape or audio tape was made by Magistrate Cronje, she never sought the consent of accused number 2, neither did she seek to advise or inform accused number 2 in the presence of his attorney that she intends recording the Section 217 interview, and also she intends recording the statement, alleged statement or confession allegedly made by accused number 2. The contrary is that Mr. Baloyi states that even though the recording, the audio recording was made according to him, it was within the state's right to present that evidence. Consequently, then, because there is a dispute regarding the admissibility of the audio recording, this court, because of the fact that there is no dispute from Mr. Baloyi representing the state that Ms. Magistrate Cronje never ever told accused number 2 that he intends recording the Section 217 pro forma question and answer, and also that she intended recording the subsequent allegedly made statement by accused number 2. Now, this court has inherent jurisdiction to invoke the Constitution peremptorily, actually, in fact, the invocation of Section 35, where the rights of accused persons are encapsulated and enshrined. In this instance, the court found it not expedient, when there is no dispute about the fact that this recording of the Section 217 interview presided by Magistrate Cronje the state alleges that it is lawfully acquired, and the contrary, the defense alleges that it was unlawfully acquired. But as I say, because there's no dispute about the fact that it was recorded without the consent and without informing the accused, this court must determine whether the Constitution in that regard, or the rights of accused number 2 enshrined in Section 35 were violated, as argued by the defense counsels here. Now, since the establishment of a democratic state in South Africa and the adoption of the Constitution 106 of 1996, South African courts are enjoined by Section 35 of the Constitution to interpret and promote the values which underlie an open and democratic society based on freedom and equality. And, where applicable, to have regard to relevant public international law, and also to permit the Section 35.5 permits our courts to have regard to comparable foreign law. Kentridge, Advocate Kentridge, SC Queen's Counsel, wrote a seminal principle into the jurisprudence of South Africa when he stated that because our Constitution is also based on a Bill of Rights, criminal trials in South Africa and criminal appeals should be conducted in accordance with the notions of basic fairness and justice. In the case of Wong Kem Ming versus R 1980, AC 247, PC 261, Lord Hallisham stated the following underlying principles. Any civilized system of criminal jurisprudence must accord to the judiciary some means of excluding confessions or admissions obtained by improper methods. This is not only because of the potential unreliability of such statements, but also, and perhaps mainly because in a civilized society, it is vital that persons in custody or charged with offenses should not be subjected to ill treatment or improper pressure in order to extract a confession. It is therefore of very great importance that courts should continue to insist that before extrajudicial statements can be admitted in evidence, the prosecution must be made to prove beyond reasonable doubt that the statement was not obtained in a manner which would be reprobated and was therefore, in the truest sense, voluntarily. In the case of R versus Tamani and others, 1925 AD, Ennis, who was then the Chief Justice of South Africa, stated that it is an established principle in our law that no one can be compelled to give evidence incriminating himself. He cannot be forced to do either that before the trial or during the trial. The principle comes through to us through English law, and its roots go back in history. Wigmore, in his book on evidence, volume 5, in page 2220, traces very accurately the genesis and indicates the limits of the privilege, and he shows that however important the doctrine may be, it is necessary to confirm it within the proper limits. What the rule forbids is compelling a man to give evidence which incriminates himself. Now, it is the norm in trials within a trial for the state to present its evidence and for the defense to present counter evidence or countervailing evidence in rebuttal of the state's evidence. Now, in this case, sorry. This court has to decide whether the audio tape recording, when it was made by Magistrate Cronier, resulted in the invasion of accused number 2's privacy and dignity, and that consequently the said audio recording evidence brought, whether the said recorded evidence by this tape under the direction of Magistrate Cronier, if it is admitted into evidence, can it be said that it would bring the administration of justice into disrepute, and that also it would be said to be an infringement of accused number 2's rights to a fair trial? The gravamen of the accused submissions, counsel's submissions, is that the reception of the impugned evidence, which is encapsulated in this audio recorded tape, would violate the accused's fundamental rights enshrined in Section 35 of the Constitution. The question is whether it could be argued that this tape can be said to be lawfully made in view of the fact that Ms. Cronier, the maker, was acting in the course and scope of his capacity as a magistrate who is presiding on behalf of the prosecution. In my view, invoking the inherent jurisdiction that I have and following the towering words of Kentridge, if the flouting of the Constitution is so egregious and flagrant, should this court wait until there is rebuttal evidence from accused number 2 regarding the fact that all he could say is that I never gave consent and I was never asked and I never knew that this interview was taped. And because of the concession by the state, and it doesn't even dispute it, that this tape was made in the course and scope of the taking of the 217 statement. This court has all the evidence regarding that exigency of legality. And in terms of Section 145, subsection 4C of the Criminal Procedure Act, this court is enjoined to decide that legal exigency without waiting for accused number 1, 2, 3, 4, 5 to give evidence in a trial within a trial when there is an egregious, according to me, an egregious flouting so flagrant that why should this court allow it to contaminate the evidence? Consequently, the reasoning this court utilized is the following. The accused has a right to a fair trial, and what infuses its purpose is for justice to be done and to be seen to be done. In considering for a purpose, the purpose of this case before court, this principle lies at the heart of a fair trial in the field of criminal justice. One has to bear in mind that dignity and freedom and equality are fundamental values of the Constitution, and these are important to the right to fair trial and to ensure adequately that innocent people are not wrongly convicted. And however, there are other elements and rights, such as the presumption of innocence, which cannot be explained exclusively on the basis of averting a wrong conviction, but which arise primarily together with the right to privacy. See in this regard the case of the Director of Economic Affairs and others versus Hyundai Motor Distributors Pty Ltd and others, 2002 SACR 349. Sorry. In my view, the submission by Mr. Baloyi that the inception and monitoring bill is applicable in this case, I beg to differ with him. It is not. when we investigate the reasons advanced by Magistrate Cronje for making that audio recording during the Section 217 interview, she stated that she recorded same for her own personal safety and because she has a penchant for recording any of her duties when she's at work and where there is no recording devices. But the point is, this recordal was made during the course and scope of her employment as a presiding magistrate in a Section 217 interview. Consequently, she may be laboring under the bona fide incorrect impression that she owns that tape. She doesn't. Sorry. So it is common cause that accused number 2 was not apprised of his constitutional rights by Ms. Magistrate Cronje, and this relates only to the audio recorded tape. It doesn't relate to the Section 217 completion of the question and answer format document, which was handed in as Exhibit JJ. The remarks which I'm making relate only to the recordal and the making of the audio recording, not to the viva voce evidence which was visited upon by Mrs. Cronje when she was engaging in the interview with accused number 2. Consequently, in my view, I have to determine whether, despite the fact that accused number 2 was not apprised of his rights, and consequently, in my view, he was not informed whether she would acquiesce to the audio recording of the entire Section 217 interview and also of the alleged statement or confession which accused number 2 made. This court, in terms of the law, it's entitled to be furnished with a pro forma format document when the maker, when Mrs. Cronje, for instance, was engaging accused number 2 in the interview in terms of Section 217. Correspondingly, one would also imagine that this court was entitled to listen to the recorded pro forma questions 1 to 13 of the audio recording. But the defense objected and said that this court will only, be indulged by the defense to listen to the tape after I have made a finding either way. That is not the law. I'm entitled. The court is entitled to listen, because we now find ourselves in this invidious position that the defense has listened to the entire tape. And I'm saying I was entitled to listen to the tape from the inception of the interview right up to paragraph 13. Mr. Balawi also has listened to the tape. The accused also have listened to the tape. And the curious oddity is that the judge who is supposed to adjudicate this matter was disbarred by the defense from listening to the tape. That was an ill-conceived and unlawful but that, as it may, this court still has to deliver these judgments. I wish to differ with Mr. Baloyi when he says the recorder, taped recorder of the section 1-2 interview and even of the alleged statement or confession made by accused number 2 is merely the basis of an electronic version of the pro forma question and answer, that is Exhibit JJ. I beg to differ. Mr. Baloyi himself advised this court that there is a difference between what is annotated in the pro forma document, the question and answer document, and what was deciphered when listening to the recording are two different versions, according to Baloyi, in that this is what persuaded him because of the extra information which he gleaned from the tape, that he should adumbrate and bring an application to tender that evidence before this court. In order for the state to supplement the evidential material in the pro forma question and answer, which was completed by Magistrate Ronye, because certain details might not have appeared on the pro forma format question and answer, but are contained in the recording, which is the basis, as it says, of merely an electronic version of the pro forma question. No, it is not. For the following reasons. Sorry, Fan. Okay. Sorry about that. I just. Sorry. Yeah. Yes, for the following reasons. In that, if Mr. Baloyi admits that the court now is confronted with two versions of the interview of the Section 217 interview presided over by Magistrate Mokgoatlheng, it means that we have the original real evidence and the supplementary evidence, which is derivative evidence, and not conscriptive evidence, as recorded by Mrs. Mokgoatlheng. And despite the injunction in the case of Key versus the Attorney General of the Transvaal, a judgment by Chrysler 1996 in the Constitutional Court, that sometimes the interests of justice and the administration of justice would be relaxed to allow that evidence which is unlawfully and unconstitutionally acquired be made admissible in a court of law. But in this instance, I'm of the view that I demur and say this cannot be done because of the egregiousness of the infraction of accused number 2's rights. And further, I've already said that it is not in the interest of justice for this court to wait for the whole evidence to be laid before this court in a full throttle application with rebuttal evidence and thereafter come to a decision because of the fact that, as we all know, decisions which or rulings which are made on admissibility in trials within a trial, those decisions are interlocutory and may later be reviewed. See in this regard R versus Musikiwa and others, 1965, 3 SA 529 SRA, a judgment of McDonald AJP, where at 530J it was said, it is important to bear in mind that a ruling of admissibility is not final. Relevant evidence led in the main trial may be taken into account by the judge or magistrate when reviewing his decision on admissibility, no matter what the source of such relevant evidence might be. There is no reason why this should not also be the position with regard to when a trial within a trial is held. And another point is that in S versus Muchindu 2002 SACR 313, Witwatersrand, Schulz, as he then was, at 3161, stated that a ruling on admissibility in a trial within a trial is interlocutory and may be reviewed at the end of the trial in the light of later evidence. S versus Mkhwanazi 1991, 1 SA 736A, this principle in fact shows that subsequent evidence in the main trial may decisively alter or affect the determination of the issues in the trial within a trial. But in this case, I want the view that the accused number two's rights to a trial, to a fair trial, were infringed by the making of the audio the recording by the magistrate Ronje. And consequently, as from the time the accused number two's rights were infringed in that manner, this court doesn't have to speculate that perhaps the accused number two would have later said he doesn't mind that these Section 217 proceedings were recorded. But this court is enjoined to declare evidence which was acquired unconstitutionally to be inadmissible, as I'm doing about the very recorder of the Section 217 interview from its beginning to its end. Because if this court allowed such an egregious flouting and flagrant flouting of accused number two's constitutional rights in terms of Section 35(5), it would not be in the interest of justice to do so, because accused number two would then be continuously subjected to a trial unfairly, when we know that the Constitution engages us and enjoins us to prevent such an exigency. And also, in the view of this court, that would bring the administration of justice into disrepute. Consequently, this court rules that the audio recording should not form part of these proceedings. It is inadmissible. Okay.
yobufakazi bala inkantolo ishike ngokomthetho ukubhekela phansi kwamalungelo akhe ummangalelo wesibili nkathi ke engatshelwanga ngayo i-recording isinqumo ke senkantolo ukuthi ayingeke ibe ingxenye yobufakazi bala enkantolo i-audio ukhulunywa nge-audio nje kuphela noma i-recording magistrate awayenzi.
Okay.
Ms. Kronyi is available for
Yes.
further cross-examination on
Okay.
Exhibit JJ.
Right.
Ms. Kronyi, she's just outside.
What's your time, Mr. Balui?
Just after 10 past. Maybe we can take the
Yeah,
normal
let's-
short adjournment
Yeah, we should.
and resume at
Yeah, sorry about that. Can you reassemble at 11:30? Thank you.